We the people.
We the people of the United States.
We the people of the United States of America did something.
The Constitution is a living document, and it is really a prescription for political struggle. It has set up institutions, the president, the Congress, the judiciary, that's the federal government, and then you have the states. Each of those institutions have dramatically changed over the last 200 years.
We the people of the United States, in order to form a more perfect union, establish justice, and restore domestic tranquility, and I can't think of one more word.
No institution in American government is the same as it was 50 years ago, 100 years ago, certainly 200 years ago.
The Constitution was written over the summer of 1787 in Philadelphia. The Founding Fathers had the goal of bringing national unity to the new country and drew their inspiration from both European thinkers of the time, such as Locke and Montesquieu, and from some distinctly American sources.
We didn't give the Constitution to the United States, but in part the framers of the Constitution were all influenced by Iroquois, Delaware, and other indigenous institutions. After all, in 1787, where was the working model of democracy in the world for the framers to embrace? Was it in France or in Spain or any? No, it was all around them. Certain principles like separation of powers and checks and balances and impeachment and referendum and initiative and recall. Indigenous peoples had those processes in their systems. And Franklin even said, if these bands of savage people can develop a democracy, the kind that we're trying to develop, then certainly we as civilized people can do this. But that's a chapter of history that has not been told.
The framers of the Constitution understood that their document would have to change to meet the challenges of the future.
Laws and institutions must go hand in hand with progress of the human mind. As manners and opinions change, institutions must advance also and keep pace with the times.
For this reason, the Constitution built both balance and flexibility into our system of government. The Constitution established 3 distinct branches of the federal government with shared powers: the executive, the legislative, and the judicial. A system of checks and balances prevents any one branch from gaining absolute control.
They each share power, but compete for power. The Constitution was designed, as I said, a prescription for political struggle for a set of institutions in which individuals will be drawn into government and then compete in trying to advance their own interests.
It's an ongoing piece that is sort of forever, whereas the working government can change and the right and left can fluctuate, but we have a solid document to always base our laws and our way of life from.
It is a written document, and it's a political document, and by definition, written documents cry out for interpretation. So the Constitution is a living document in the sense in which it cries out for the public and, of course, Supreme Court justices to give it meaning in light of changing circumstances.
The process by which the Supreme Court interprets the Constitution is called judicial review. This principle was established in the landmark case of Marbury versus Madison in 1803. In this case, Chief Justice John Marshall established the Supreme Court as the final authority on the meaning of the Constitution. Although judicial review has been used rarely, it has a huge impact on United States society, often moving ahead of Congress in addressing social issues. For instance, in 1973, in the landmark case of Roe v. Wade, the court ruled that the 9th and 14th Amendments rendered specific state laws prohibiting abortion unconstitutional.
Congress and the courts have to continually struggle with the effects of new technologies, of changing social expectations. I think that in general, courts tend to be the institution that first speaks on these issues because litigation is brought. The court then rules, and Congress may try to override the court or it may respond. But many of the social civil rights issues in this century, Congress would not have addressed had it not been for the court ruling on the issue.
The Supreme Court has traditionally been reluctant to overturn one of its previous findings. In Brown versus the Board of Education, the court made an exception, overturning the 1896 Plessy versus Ferguson decision that allowed segregation in the South. The Supreme Court now stated that separate is never equal.
My fellow Americans, I am about to sign into law the Civil Rights Act of 1964.
Clearly, Congress would have never passed legislation desegregating public schools if it were not for the court's ruling in Brown versus Board of Education in 1954. We would not have had the Civil Rights Act of 1964 passed by Congress forbidding discrimination.
President Woodrow Wilson called the Supreme Court a constitutional convention in continuous session. The significance of judicial review is reflected in the fact that it has been incorporated in one fashion or another into the constitutions of nearly 100 other countries. The continued vitality of the Constitution is derived in large part from the conceptual broadness of its language. This allows flexibility in its interpretation and usage to deal with a changing society.
Early in our nation's history, the court had the opportunity to interpret state laws and whether they violated Congress's power. In the great case of Givens versus Ogden, Chief Justice John Marshall gave a very, very broad interpretation of what does interstate commerce mean. He defined it as intercourse that passes through state lines or over state lines. That word, intercourse, is of course pregnant with possibilities because it is a word which can describe what at the time was an agricultural country and the transportation of agricultural products. But intercourse is broad enough to cover railroads, it's broad enough to cover the internet, it's broad enough to cover telecommunications of all sorts. And so, because of Chief Justice John Marshall's creative and expansive reading of the Interstate Commerce Clause, Congress has the power to regulate virtually any matter that crosses interstate lines or is involved in intercourse among more states than one.
The Commerce Clause is the means Congress has used to extend federal power to areas that would otherwise have belonged exclusively to the states.
All Congress had to do was to identify a national problem that affected interstate commerce. Most of federal criminal law, that is, say, law that makes an activity a crime subject to federal prosecution in contrast to state prosecution, is passed under the Interstate Commerce Clause.
Because of modern technology and the global nature of today's economy, almost every commercial action affects more than one state. Even garbage has come under the jurisdiction of the Commerce Clause, as waste disposal has become an interstate and international concern.
Congress has used these powers more and more expansively, and indeed for about 60 years, the court supported Congress's expansive use of its powers, upholding civil rights acts, for example.
But some argue that this expansion of powers comes at the expense of the rights reserved to the states under the 10th Amendment of the Constitution.
To begin decisively changing the shape of the government.
The Rehnquist Court has tried to cut back or limit Congress's power under the Commerce Clause in deference to the states, because many times Congress will force states or local governments to perform some service, such as checking gun registration. That was the Brady Bill. The court struck that down in 1997 on the grounds that it was an unfunded federal mandate, that it exceeded Congress's power under the Commerce Clause and violated the 10th Amendment, which reserves rights to the states. So there is an ongoing debate about Congress's power under the Interstate Commerce Clause, and an ongoing debate about how far the federal government's power should extend and where the boundary or powers and authority reserved entirely to the states should be drawn.
The Constitution has remained a living document through a variety of means. One critical component is the amendment process, which allows the people of the United States to make permanent changes to the Constitution.
Those amendments have made the Constitution a more democratic document, a more inclusive document.
The first 10 amendments, ratified together in 1791, occupy a special place in the lives of United States citizens.
To me, the Bill of Rights is, shows what, if not all, but maybe the most basic, the rights that that all people should have.
Well, it's a guarantee to the American people that their rights will be protected.
What it means to me is that it just gives me a guideline as to what I'm free to do in this country.
That's what our country was based on, was the Bill of Rights.
It gives rules or something. It gives you freedom. I mean.
The Bill of Rights was added to the Constitution to guarantee the rights of individuals.
It was what our founding fathers saw in the future, that they could deteriorate and that we would gradually lose our rights. And this was a way of preserving them, and every time that someone wants to make some changes, they're looked at very, very closely.
The Bill of Rights affects all people in the United States every day. Some of the rights guaranteed in the Bill of Rights are almost taken for granted today. One is almost forgotten, and others remain controversial.
I think that every American should have the right to have a weapon in their home for protection.
I think that this is a very touchy situation. I realize we don't need assault weapons, that's for sure, for the general public, but the right to bear arms was there for our protection. We should have that right, and that is being questioned today.
I think my due process rights is most important to me.
Fourth Amendment, search and seizure. I can't recite it word for word, but it's about search and seizure and the fact that you have to have probable cause and stuff like that to search your bags.
You get search warrants pretty easily nowadays, which is okay and good because it does help solve crime. However, when some innocent person's rights are stepped on by kicking in a door of someone who's done absolutely nothing.
If the police are allowed to randomly do whatever they want, then many people will be harmed in certain ways.
I mean, just the First Amendment is a whole world of what it means to be American and our rights.
No amendment is debated more than the first, which guarantees freedom of religion, speech, a free press, and the right to peaceful assembly.
Over-litigated, overused, and abused.
I think anything should be censored. I don't believe in censorship in any way. And I just think that freedom of the press is essential. It's an important part of American life. Because the next thing that'll be censored is something that I feel strongly about, I'm sure.
Well, I can speak freely for what I believe in.
Yeah.
Sure. And not like we are now.
We don't have total freedom of speech, but we have it more to an extent, and we are more of a free country than the rest of the world is, basically. In those places, you said anything bad about the government like this, you'd be hunted down and shot.
Freedom of assembly, I believe, is a very important issue right now.
Everybody has the right to speak their mind at the right time and the right place.
There's a whole lot of us that don't say it very well, but hopefully, and that's what, there again, that's what made America, is the right to speak our piece and to get out there amongst them.
I'm currently trying to comprehend First Amendment, freedom of expression. This balloon thing is a form of artistic abstract expression, but I don't know what it says.
The Bill of Rights democratizes the Constitution, giving many of the values of the Declaration of Independence legal backing.
Bill of Rights are the framework by which we have this country. It distinguishes this country from other countries. It is what we're about, even if we don't do it very well.
It's being American. It gives everyone supposedly the opportunity to seek out and pursue their dreams.
210 years ago, we the people, of which the Constitution speaks, was very limited. It spoke primarily to propertied white males.
The amendment process has been the foremost method of making the Constitution and U.S. government more inclusive. Expansion of the rights of individual citizens has been the subject of 8 of the 17 amendments passed since 1791. Struggle for the rights of women began years before the Constitution was ratified.
The women's rights movement in the United States has had 2 great waves, and both of them grew out of the civil rights movement in one sense or another.
Women were very active in the abolitionist movement or the anti-slavery movement, and it was in the course of their struggling to help free what we said were Negroes in those days, they realized that they themselves were not free, in that they had no voice, they were not in government, they had nothing to say.
The 14th and 15th Amendments, passed after the Civil War, granted African American males the right to vote. The 14th Amendment additionally forbids states from denying any person within its jurisdiction the equal protection of the laws.
Traditionally, the Supreme Court did not read women's equality into the Equal Protection Clause. And so despite the Equal Protection Clause, states were allowed to prohibit women from practicing law, to prohibit women from voting or serving on juries. The court basically found any reason or any excuse to say that's okay with us.
They said it applied only to race. So here was this enormous struggle that had taken place. It was an irony, so to speak, in which women were very happy to see that the 14th Amendment gave rights to people regardless of their race, but not regardless of their sex.
Women such as Elizabeth Cady Stanton and Susan B. Anthony organized the National Women's Suffrage Association to fight for women's right to vote.
The fight for the 19th Amendment, the amendment that gave women the right to vote in this country, was a long and hard-fought battle.
It took 75 years. It was hard, back-breaking work, state by state, locality by locality, run by some wonderful women who went from place to place by horse and buggy, held meetings, gave out leaflets, made declarations, ran newspapers. It was a big, big movement in this country.
When women began struggling for the right to vote, they weren't even allowed to speak in public by custom and convention in the country. And they, by even speaking out loud about their desire for the right to vote, were really challenging at a very basic level the proper roles of women in society. They had marches, tremendous pageants of marches with everyone dressed in white and with their suffrage colors, gold, purple, and white on banners that floated down the avenue. They engaged in civil disobedience at the very gates of the White House, chaining themselves to the White House fence.
They made appeals to every kind of state and federal legislator, to presidents, that this country could not really call itself a democracy if a majority of the country, which women are, did not have the right to vote.
In 1920, the 19th Amendment became the law of the land.
I think that most people felt that when they got the vote, that they would then get everything that went with it: equal employment, equal rights, non-discrimination in the professional schools, and so on. All of that did not take place right away. And so it then required a renaissance, so to speak, of the women's movement, of the suffragist movement, which didn't take place till the 60s, where women realized that they were second-class citizens and decided that as part of the general changes that were taking place, the civil rights movement, peace movement, and other movements, that women had an insufficient opportunity to participate in what was their own society, in their own government.
We know that beauty and brains are not mutually exclusive. We know that we can be as competent in the boardroom as the bedroom. We know that.
An Equal Rights Amendment had been introduced in 1923. With the resurgence of the women's movement, it gained enough support to pass Congress in 1972.
When we saw under the Equal Protection Clause of the 14th Amendment that for decade after decade the court did not see any discriminatory law it didn't like, we really felt that we needed an amendment that was specifically designed for women. And indeed, the women who won the right to vote began just a few years later by saying they had to finish the job of getting constitutional equality for women with the Equal Rights Amendment.
The wording of the amendment was apparently simple. Public support for it crossed both party and gender lines. By 1975, nearly half of the state legislatures had ratified the Equal Rights Amendment. But then the proposed amendment became the basis for fervent opposition.
Many of the arguments were not really relevant, but very emotional, visceral arguments. If the ERA passes, you will lose the support of your husband. You'll probably even have to pay his debts. We'll have unisex bathrooms. Your daughters will be drafted and thrown into the foxhole in some hot country around the world. And so the challenge came to people at a very basic level.
We have no desire at all to take over the male role. This revolution, and it is a revolution, not a reform, is about humanizing both roles, not exchanging them.
The opposition proved effective. By 1978, 35 of the 38 states required had ratified the ERA, but it stopped there.
It failed because state legislators, many of whom had run as pro-ERA supporters, then turned their back on us and voted against us, and we ran out of time.
So it's been a big struggle, and it's still not over. Although much progress has been made. Much progress has been made.
You know, if you look around any workplace, you'd see the dramatic changes that we've made in the last 30 years. But we do see that in many ways women are disadvantaged in our societies.
There's still a wage gap, and women are still having a hard time getting through the glass ceiling, which means getting beyond a certain stage in corporate America, or getting off, as I usually like to put it, the sticky floors, where they get maybe minimum wage or less. You know, I've always said since the time, well, it would be nice to have an Equal Rights Amendment, but we have to just declare that we are equal and act on it.
The Constitution is designed as a political balancing act, allowing it to adapt to changing times.
America is tearing itself down.
What issues will challenge the Constitution as we enter the new century? What new rights might evolve? Will the power of the federal government continue to expand? Or will a more conservative Supreme Court reassert the 10th Amendment rights of the states?
Congress and the courts have to continually struggle with the effects of new technologies, changing social expectations.
Many of the issues facing our nation concern a right to privacy. This right is not mentioned explicitly in the Constitution or its amendments, and until recently was not recognized by the Supreme Court. However, in the 1960s, the court changed its view. In Griswold versus Connecticut, the court ruled that Americans are guaranteed zones of privacy, protected from the government. The right of privacy has expanded to cover a range of individual rights. In Roe versus Wade, the Supreme Court ruled that states could not totally ban abortions.
That grew out of a line of earlier cases that began really with the forced sterilization of prisoners. And the courts had said that the right to reproductive freedom is so fundamental that there is a high level of protection against government intrusion on those very personal, intimate decisions. Because the right to privacy is read between the lines of the Constitution, developed as court-made interpretation, it too is subject to reinterpretation.
Privacy issues today include same-sex marriage and the right to die. Technological changes also raise privacy and free speech issues. Do conversations on cell phones receive the same protection from government eavesdropping as regular phones? Who gets to control what is seen or said over cable TV? On the internet?
As we enter the next century, we're entering a global village in terms of international political economics and in terms of information exchange. And so the principal issues will be production of knowledge and access to knowledge.
In the more than 200 years of its existence, the Constitution has faced growing demands and expectations of we the people. The overall result has been increasing responsibility for the national government, as well as an expansion of rights for individuals. This pattern may continue into the 21st century, or it may take a different road, depending on the response of Congress, the courts, and the voters of this country. While we cannot predict the future, it is a safe bet that the Constitution will endure because of the flexibility that has kept it a living document.
We the people, in order to form a more perfect union, establish justice.
Establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare of ourselves and our prosperity. Do ordain this Constitution of the United States of America.
It's in me to know what it is without the words per se memorized.
Thank you.